Good morning, everyone. I am Jyotsna Parmar, studying in LLM. My specialization subject is alternative dispute resolution. Today we are discussed about alternative dispute resolution. In this section, we discussed and talked about arbitrations and mediations. So let us start with arbitrations. Good evening everyone. Today we are discuss about alternative dispute resolution system and one of the alternative dispute resolution arbitrations. Alternative dispute resolution is a process that helps people to solve civil disputes without actually going to court. There are three known methods of alternative dispute resolutions, that is, arbitrations, conciliations, and mediation. Arbitrations is the method of alternative dispute resolution that helps the parties to resolve the disputes amicably. With the help of arbitrator, courts are overburdened with the massive number of cases because of which decisions and judgments get delayed. People file petitions in the courts in the hope to get justice, spends a lot of money and time in the legal procedure. But because of overburden, the courts are not able to render the decision on time, and when the judgment finally comes, it's not worth the cost of what was already spent, that is a lot of time and money. Therefore, alternative dispute resolutions are very helpful to reduce burdens of courts and to get justice speedily. One of the most effective alternative way is arbitrations. In ancient times in our country, using techniques of arbitrations and conciliations to resolve disputes. Industrial revolution has led to a rapid increase in global trade and commerce. To stay with the economic growth and avoid long court trials, the parties often resort to arbitration as the preferred mechanism to solve the dispute among them. In the era of monarchy, arbitration was the form preferred by the rules for resolving territorial and commercial disputes. In India, Arbitration and Conciliation Act was introduced in year 1996, which came into force on 22 August 1996. The main object to introduce the Arbitrations and Conciliations Act was to maintain hostile relationship while conducting international and domestic business. It was also enacted to minimize the role of the courts and help the courts to reduce their burden. Arbitration is the process of resolving disputes among the parties by bringing the disputes in front of the third party, who is a neutral person. The third party is known as the arbitrator. To reduce the burden of litigations, the method of arbitration is used in the hope of settling a dispute without spending the cost and time to approach the court. At the end of the arbitration proceedings, the decision rendered by the arbitrator is binding on both parties. In the process of arbitration, there is a hearing conducted to determine the cause of conflict between the parties by the person who is appointed as an arbitrator by the parties or by the statutory bodies. The main purpose of arbitration is adjudication, and there is no place to compromise. After determining the cause of conflict and hearing both sides of the party, the arbitrator enforces their point of view that is neutral and fair. The process of arbitration cannot exist without the arbitration agreement. An arbitration agreement is a document where two parties enter willingly, which state that if any dispute arises between them out of that certain contract, that will have to be solved without going to the courts and would be resolved by appointing a neutral person as a third party. The definition of the arbitration agreement is given in section 2(1)(b) and section 7 of the Arbitration and Conciliation Act. The Arbitration and Conciliation Act was recently amended in the year 2020 by introducing the Arbitration and Conciliation Amendment Ordinance 2020. The ordinance focused upon the unconditional stay of enforcement of arbitral award if the court finds fraud or corruption. Now we see international commercial arbitration. International commercial arbitrations help to resolve dispute among the international parties arising out of the international commercial agreement. Section 2(1)(f) of the Arbitration and Conciliation Act defines international commercial arbitrations as disputes arising out of the legal relationship where one of the parties is a citizen, resident, or habitually residing out of India. International commercial arbitration is used by the traders of different countries as a way of settling their business conflicts. The procedure to apply for international commercial arbitration is the same as domestic arbitrations. The scope of section 2(1)(f) of the Arbitration and Conciliation Act was determined by the Supreme Court in the case of TDM Infrastructures Private Limited versus UE Development India Private Limited. In this case, it was held that if the company has dual nationality, the means it is registered in foreign and in India, then that company for this act would be regarded as Indian corporation and not the foreign corporation. International commercial arbitration allow the parties to resolve their disputes amicably by maintaining their relationship and with less money by respecting each other's cultural and linguistic background. International arbitration is also known as hybrid form of international dispute resolution. Because international arbitration allows mixing two legal provisions, the Code of Civil Procedure and the Common Law Procedure. Parties coming together to work often in their legal contract mention the clause of the arbitration agreement to resolve the disputes without going to court. The International Chamber of Commerce ICC model arbitration clause for instance merely reads all disputes arising out of or in connection with the present contract shall be finally settled under the rules of arbitration of the International Chamber of Commerce by one or more arbitrations appointed by the said rules. Now we see steps involved in international commercial arbitrations. There are various steps involved while conducting the proceedings of the international commercial arbitrations. The steps are explained as first of all, notice of arbitrations. To commence the proceedings of arbitration, one party has to provide the notice of arbitration to the other party requesting to refer the dispute to arbitrations. When the respondent receives the notice of arbitration, the proceeding of arbitrations begin. In this notice, there are two essentials. One is the communications of an intention to refer the dispute to arbitrations, and the other is that the other party to whom the notice has been served should take a step towards it. The judicial authority can refer the subject matter to, of the case to the arbitrations if that agreement contains the clause of arbitration to settle the disputes among the parties. If there are any, according to Section 8 of the Arbitrations and Conciliation Act, the judicial authority can refer the parties to arbitrations if there is an arbitration agreement. Now we see appointment of an arbitrators. The parties are at their discretion to appoint the arbitrator to decide their case. If the parties are not able to appoint the arbitrators mutually due to some issue, then the court allow the parties to appoint each arbitrator, and then these two arbitrators will appoint the third party who will be neutral person. If the parties fail to appoint the arbitrators within 30 days or the two arbitrators fail to appoint the third arbitrator, then the parties can request the Supreme Court and High Court to appoint the arbitrators. The High Court or the Supreme Court can appoint any person or institution to appoint arbitrators. In the cases of international commercial arbitration, the Supreme Court can appoint the arbitrators for the parties, and in the cases of domestic arbitrations, the High Court appoints the arbitrators. The challenge to the appointment of arbitrators. The appointment of arbitrators can be challenged only on these two criteria. 1. Where there are circumstances that raise reasonable suspicions about his or her independence or impartiality, or the arbitrators does not possess the qualities the parties require. The mandate of the arbitrators. If arbitrators do not deliver the arbitral award on time, then the mandate of the arbitrators expires. This was held in the case of NBCC Limited versus JG Engineering Private Limited by the Supreme Court. The mandate of the arbitrators expires according to the period agreed by the parties. The Arbitrations and Conciliation Act, in Section 9, it provides for interim measures of protection not just before the commencement of arbitral proceedings and during the arbitral proceedings, but also after the arbitral award has been delivered. Section 17 provides for interim measures ordered by the arbitral tribunal if it is found at the time of proceedings that the disputed matters is dangerous, then it can ask the party to provide security. The Supreme Court, in the case of SBP and Company versus Patel Engineering, held that if without judicial intervention the arbitral tribunal was constituted by the parties, the arbitral tribunal can determine all jurisdictional issue by exercising its powers of competence under Section 16 of the Act. The parties are allowed to settle the dispute mutually even if the arbitration proceedings are going on. If the parties arrive at this settlement amicably, the arbitral proceedings will be terminated. Arbitral award. The decision rendered by the arbitrator in an arbitration proceeding is known as an arbitral award. The decisions are taken by taking the view of both the parties and by the majority. An arbitral award should be in written form, signed by all the members of tribunals. In the arbitral award, the date and place were mentioned. It is made should be mentioned. Each party is entitled to acquire a copy of the arbitral award. Thank you. Good morning. Today's topic is mediation. Mediation is a dynamically structured dispute resolution process where a neutral third party helps the disputing parties in resolving a conflict between them by using specialized communications and negotiation techniques. These techniques are in turn designed in a manner that facilitates the process of mediation and dispute resolution. Mediation is an age-old process of dispute resolution practiced since Vedic period. It is a low cost, keeping the matters, especially family matters, secrets among three parties, two parties and the mediator. Moreover, the solution is not imposed on any party. It is a solution that both the parties agree to it, thus gives an effective solution in a peaceful manner. Since long, mediation as a mode of dispute resolution is in practice in our country. Section 89 of the Code of Civil Procedure, as amended in the year 2002, has opened the scope for alternative dispute resolution, that is, arbitrations, conciliations, mediations, and pre-trial settlement methodology. Mediation is one of the effective and now well-known alternative dispute resolution method, which helps the litigants to resolve their disputes voluntarily and amicably with the assistance of a third party known as mediator. The mediator, by his skills, assists the parties to settle their dispute through mediation proceedings. Parties arrive at equitable solutions and are always in win-win position. Mediation proceedings are informal process in which the mediator, as a third party without the power to decide or usually without enforcing a solution, helps the parties resolve a dispute or plant a transactions. These proceedings is usually voluntarily, confidential, transparent, and time and cost effective without any agony, and they also save their valuable times and expenses of litigation as well. Alternative dispute resolution method of resolving the disputes is relatively new trend in India. The mediation process in India is not a newly invented procedure for dispute redressal. It is a beneficial for both the sides. The courts are being a bit less burdened with cases, and the parties are getting their issues resolved quickly with less hassle and in a smoother way. Thus, there has been made an important position for mediation in Indian law. Now we say that what is mediation? Mediation in India is a voluntary process where the disputing people decided to mutually find a solution to their legal problem by entering into a written contract and appointing a mediator. The decision making powers remain with the disputing parties, with the mediator acting as a buffer to bring them to an understanding. The parties can hire ADR lawyers to represent them before the mediator and explain the situation in a professional way. The difference between arbitrations and mediations are that arbitration is a more formal process than mediation. An arbitration needs to be formally appointed either beforehand or at the time of need. A mediator can be anyone of any designations, can be appointed formally or casually, depends on the width of the parties. The mediation law in India has been made user friendly and pretty flexible. Mediation in India are divided into two categories which are commonly followed: court referred mediation and private mediation. First of all, referred mediation is that the court may refer a pending case for mediation in India under section 89 of the Code of Civil Procedure 1908. This type of mediation is frequently used in matrimonial disputes, particularly in divorce cases. The second one is private mediation. In private mediation, qualified personnel work as mediator on a fixed fee basis. Anyone from courts to the general public to corporates as well as the government sectors can appoint mediator to resolve their disputes through mediation. The historical background about the mediation process is, in olden days, before formation of law code in India, people were settling the matters of disputes by themselves by mediation. The mediation was normally headed by a person of higher status and respectable among the village peoples, and such mediation was called panchayat. It also called village panchayat and caste panchayat. Panchayat, which act is informal mechanism dispute resolution. The pancha is a person of integrity, quality and character who will be deemed to be unblessed of people of the locality called village headman, that is sarpanch. He was assisted by some people of same character or cadre from several castes in the locality. The disputes between individual and families will be heard by the panchayat, and decision given by the panchayat will be accepted by the disputant. The disputes in olden days seldom reached law courts. People were settled their family disputes, civil disputes as well as criminal disputes, and such type of dispute resolution techniques largely based on coexistential justice. Therefore, there was a necessity to bring together a detailed provisions for better implementation of mediation mechanism. Statutory provisions for mediation in India. Mediation is a method of alternative dispute resolution in addition to arbitration, negotiation and conciliation. It is a negotiation facilitated by a neutral third party known as a mediator. But unlike arbitration, mediation does not give the mediator the power to make a decision in order to settle the dispute. Mediation is a voluntary process most of the time and it requires consent of the parties, a term in a contractual agreement or mandate by a court. The process is different from litigation because parties have facilitated conversations and make compromises in order to resolve the dispute on their own rather than having a judge decide who wins and who loses. Furthermore, the mediator supervises exchange of information and bargaining between the parties and can even suggest creative solutions to help the parties find common grounds and work past unrealistic expectations. Since courts in India are already burdened by a huge backlog of cases, there are many statutory provisions that make mediation a compulsory prerequisite to filing of a suit in court. Some of the statutes are as under. First, Section 4 of the Industrial Disputes Act 1947. Conciliators appointed are assigned with the duty to mandate and promote settlement of industrial dispute with detailed prescribed procedures for conciliation proceedings. Section 89, read with Order 10 Rule 1A of the Code of Civil Procedure 1908. The insertion of Section 89 in the CPC is itself a welcome step toward promoting mediation and other means of alternative dispute resolution. As per Section 89, read with Order 10 Rule 1A of the CPC, after recording the admission and denial of documents, the court shall direct the parties to the suit to opt for any of the modes of settlement outside court as specified in Section 89(1) of the CPC. That is arbitration, conciliation, judicial settlement, including settlement through Lok Adalat or mediation. Therefore, it provides for the reference of the cases pending before the courts to the aforesaid modes of dispute resolution. Order 32A of CPC. It recommends mediation. This is evident from Rule 3 and 4 of Order 32A. The legislator have very thoughtfully inserted these provisions because the matters compromising of, but not limited to, personal, family, matrimonial, guardianship, custody, and maintenance. These matters can be more aptly resolved through non-adversarial means. There may be disavowing positions by the parties, but the effort has to be protect the underlying interests, which can be done through mediation. Section 442 of the Companies Act. Section 442 of the Companies Act 2013 provides that the central government shall maintain a panel of experts called the Mediation and Conciliation Panel, consisting of such members of expert having such qualifications as may be prescribed for mediation between the parties during the pendency of any proceeding before the central government or the tribunal or appellate tribunal under this act. Section 14(2) of the Hindu Marriage Act and Section 29(2) of Special Marriage Act. As per Section 14(2) of the Hindu Marriage Act 1955, in disposing of any application under Section 14 for leave to present a petition for divorce before the expiry of 1 year from the date of marriage, the court shall have regard to the reasonable possibility of a reconciliation between the parties before the expiry of 1 year. Therefore, probability of a reconciliation between the parties before the expiry of 1 year. Therefore, the intent of the legislature is that the court should in the first instance attempt mediation between the parties. Similarly, a provision contained in Section 29(2) of the Special Marriage Act, unlike the adversarial system in which the competent claims of parties are represented by legal representatives who have interest in the outcome of dispute in matrimonial and family matters, it is important to visualize and analyze the underlying interest of the parties, no matter however diverse may be their position. It is the skill of the mediator to facilitate the party to try to arrive at an amicable solution or settlement. Section 32G of the Real Estate Act 2016. It provides that function of the authority for the promotion of real estate sector. Subclause G of Section 32 of the Act stated that the authority shall, in order to facilitate the growth and promotion of a healthy, transparent, efficient and competitive real estate sector, make recommendation to the appropriate government of the competent authority as the case may be, to facilitate amicable conciliation of disputes between the promoters and the allottees through dispute settlement forums set up by the consumer or promoter associations. The Law Commission of India reports 129th. The Law Commission reports recommends courts to refer dispute for mediation compulsorily. Section 12A of the Commercial Courts Act 2015. Section 12A of the aforesaid Act under Chapter 3A deals with pre-institution mediation and settlement. It has been inserted by 2008 amendment to the Act. Section 12A clearly states that a suit which does not completely any urgent interim relief shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. It is therefore mandatory for the parties to exhaust remedy of pre-institution mediation under the Act before the institution of a suit. The Commercial Courts Rules 2008. The central government has framed and thereafter notified these rules on July 3, 2018 in exercise of its powers conferred by subsection 2 of section 21A read with subsection 1 of section 12A of the Commercial Courts Act 2015. Again, section 37 and 38 and chapter 5 of the Consumer Protection Act 2019. The aforesaid provisions provide for disputes covered under this act to be first referred to mediation. It has been clearly provided under section 37(1) of the aforesaid act that at first hearing of a complaint after its admission or at any later date, if it appears to the district commission that there exist elements of a settlement which may be acceptable to the parties, it may direct the parties to give in writing within 5 days their consent to refer the matters to mediation, and the provision of chapter 5 of the act shall apply. Mediation and Conciliation Rules 2004. In exercise of its power under Part 10 and Section 89, subsection 2d of CPC, the Honorable High Court of Delhi has framed this rule. In mediation process, the mediator works together with parties to facilitate the dispute resolution. A mediator's role is both facilitative and evaluative. A mediator facilitates when he manages the interactions between the parties. He encourages and promotes communication between them and manages interruptions and outbursts by them and motivate them to arrive at an amicable settlement. The difference between taking a matter to litigation and taking it for mediation process is that in litigation there is a blame game and blames are to be proved, depending that the court shall give a solution, and in mediation the matters get resolved through negotiation where the solution is sought with the consent of the parties after considering the demands of both sides. Now we see process of mediation. In most cases, people voluntarily opt for mediation to mutually resolve their legal issues, making mediation in India a party-centric and neutral process. A mediator is appointed who acts unbiasedly in directing the parties to amicably resolve their issues. The mediator helps them to reach a conclusion based on their agreed upon terms. As it is a voluntary process and the parties remain all the rights and powers, any party can withdraw from the process of mediation at any stage without stating a reason. Mediation encourages the parties to participate in dispute resolution actively and directly, whereby they explain the facts of their disputes. lay down options or ways to resolve the disputes and make a final decision by coming to a settlement. The mediation process in India follow all the general rules of evidence and examination and cross-examination witness. To know all the legal rights you have over the issues, you can discuss with your ADR lawyer how you can put up your demands and negotiation it with the other party. The mediator works together with parties, facilitated the dispute resolution mediation process, and does not adjudicate a dispute by imposing a decision upon the parties. The process of mediation in India is completely confidential, as any information furnished by any party and a document prepared or submitted is inadmissible and sealed. Any admission made during mediation process cannot be used in any other court case, and any information provided to the mediator cannot be disclosed to the other party unless the other party specifically permits the mediator to do so. The mediator cannot be called as a witness to testify in any court case and cannot disclose any information related to the proceedings. At the time, even the court refer mediation, as it is an easier and quicker process to get a resolution. Especially the divorce mediation in India is most common method of mediation. The mediation in divorce cases, property cases, family matters help to keep the matters limited to the parties only and does not bring it before public and reach to a solution, maintaining the peace and future relations. Now we can see that, is mediation legally binding to all? Mediation is an alternative way for resolving a dispute between uh, disputing parties without resorting to the court. In mediation proceeding, a mediator who is a neutral third party facilitate a dialogue between the two sides in a disputes and works with them to help arrive a settlement. However, there is no law regulating mediation in India, and the agreement arrived at after mediation is non-binding. Disputes are many times taken to the courts even after mediation, resulting in loss of significant time in mediation without any fruitful outcome. Now, which type of cases are referred for the mediation? There are suitable cases for mediation like civil cases of different nature where the parties agree for mediation are generally fit to be referred to the mediation. But certain cases are particularly appropriate for referral to mediation, and they are cases pertaining to recovery of money, rent, partition, matrimonial dispute, labor dispute, specific performance damages, injunction, declaration, dispute between landlord and tenant, check bounce cases, motor accidents claim, etc. are suitable cases. Include offences covered under section 320 of CRPC. One of the fundamental principles of mediation is that parties be properly informed of their rights and they be prepared for negotiation to reach agreements which satisfy their need. In mediation, the key to success depends on judges referring appropriate cases for mediation. The referral judges has to ascertain whether there exist elements of settlement. Then only a case has to be referred for mediation. There are some disadvantages of this process which are as under. One of the biggest disadvantages of mediation process is that it can be very difficult to make sure that the settlement is fair to both parties. If one party has access to more resources or is severe about the mediation process, they may be able to get the other party to agree to a settlement that isn't in their best interest. It is very common for mediation to end without the parties successfully reaching a settlement agreement. For instance, the parties might spend a tremendous amount of money, effort, and time only to find that resolving a dispute through mediation is impossible and that they will need to go to court after all. When mediation is unsuccessful, it can make a court case more difficult, as one of the parties may have already used their best evidence, meaning the other party will know what to expect during the trial. In order to protect their privacy, the parties may decide to keep their sessions private so that the information discussed does not become public knowledge. Mediator, while they have some ability to bring balance to these sessions, are limited in how much they can actually do. Unlike state and federal courts, there are no constitutional protection available in mediation. Setting legal precedents in mediation isn't possible. Okay, thank you.